global controls will have to be imposed, and a world governing body will be created to enforce them. Crises precipitate change.
Secretly plotting your demise. I want to devise a virus.
Hello everyone, Dargo 2012 here with Global Government News, and I'm covering an article titled Police Push for Warrantless Searches of Cell Phones. This was from February 18th, 2010, and it says, when Christian Taylor stopped by the Sprint store in Daly City, California last November, he was planning to buy around 30 BlackBerry handhelds, but a Sprint employee on the lookout for fraud grew suspicious about the address and other details relating to Taylor's company. It said Univercity, and called police. Taylor was arrested on charges of felony identity fraud. His car was impounded and his iPhone was confiscated and searched by police without a warrant. A San Mateo County judge is scheduled to hear testimony on Thursday morning in this case, which could set new ground rules for when police can conduct warrantless searches of iPhones, laptops, and similarly capacious electronic gadgets. Not sure if I pronounced that properly, but it says this is an important legal question that remains unresolved. As our gadgets store more and more information about us, including our appointments, our correspondence, and personal photos and videos, what rules should police investigators be required to follow? The Obama administration and many local prosecutors answered that warrantless searches are perfectly constitutional during arrest. It says there are very, very few cases involving smartphones. Chris Fiesel, Deputy District Attorney for San Mateo County, said in an interview on Wednesday, quote, "The law has not necessarily caught up to the technology." Fiesel said the county's position is that a search of a handheld device that takes place soon after an arrest is lawful. It is an interesting issue that may decide the future of how courts handle these kinds of cases, especially smartphones and iPhones, he said. Attorneys for the Electronic Frontier Foundation, the San Francisco Civil Liberties group that representing Taylor, have asked the court to suppress any evidence obtained from the search of his iPhone. They say the search was unconstitutional because it was done without a warrant, and they say it also may have violated a 1986 federal law designed to protect the privacy of email messages. Privacy advocates say that long-standing legal rules allowing police to search suspects during an arrest, including looking through their wallets and pockets, should not apply to smartphones because the amount of material they store is so much greater and the risk is intrusive. Searches are so much higher. A 32 gig or gigabyte iPhone, 3 gigs, for instance, can hold approximately 220,000 copies of unabridged text of Lewis Carroll's Alice's Adventures in Wonderland. And it says, quote, neither the search of Taylor's vehicle nor the search of his iPhone was justified by any exception to the warrant requirement, the EFF and his co-counsel, San Francisco Attorney Randall Gartsire, wrote in a brief he found earlier this month. And it goes on and talks about sex photos drew federal lawsuit. Concerns about privacy are not merely hypothetical. In March 2008, Nathan Newhart was arrested on suspicion of drunken driving in Culpeper, Virginia, and his cell phone was seized. In the pictures folder of the cell phone were multiple pictures of Newhart and his then-girlfriend, Jessica Casella, nude in sexually compromising positions. Okay, Newhart and Casella, at that point, no longer a couple, filed separate civil lawsuits against Sergeant Matt Borders, who they say altered the rest of the police department on the radio. Alerted the rest of the police department on the radio, and quote, that the private pictures were available for their viewing and enjoyment. Newhart claimed that as a result of the incident, he was non-recommended for continued employment with the Culpeper school system where he had worked before the arrest. A federal judge in Virginia last year agreed that the police conduct was, quote, irresponsible, unprofessional, and reprehensible, but said that Culpeper police officers could not be held legally responsible because they did not violate any clearly established constitutional rights. In addition, the court pointed out the Fourth Circuit Court of Appeals had ruled that, quote, officers may retrieve text messages and other information from cell phones and pagers seized incident to an arrest to preserve evidence. So, already you can kind of see it's, you kind of, at your own, use those phones and carry them around with you at your own risk and all the information you put on them, I guess. It says the problem for EFF and its co-counsel in the San Mateo County case is that while the U.S. Supreme Court has not taken up the issue, a number of other courts have reached similar conclusions. In 2007, the Fifth Circuit concluded that police were permitted to conduct a warrantless search for all call records and text messages during an arrest. So did the Seventh Circuit in a 1996 case dealing with information from numeric pages. Says that it is imperative that law enforcement officers have the authority to immediately search or retrieve incident to a valid arrest information from a pager in order to prevent its destruction as evidence. And it's one-sided, right? It's going to be selectively enforced because if you're taking pictures of the Federal Reserve building or you're just taking pictures of something that, the establishment and the law enforcement that protects the establishment, they don't want you to have. So they'll take your camera, they'll confiscate it, they'll remove and delete all the pictures off of it, and then they will give it back to you if you are lucky. Same with the cell phone as well, so it's just a law that's going to be selectively enforced. There's a good case that the police, as awful as it sounds, should be able to go through the contents of the phone. Said a professor of the South Texas College of Law who has written a paper on the topic. Quote, courts for the most part have held that a phone is like a container, a wallet, or a purse. Then again, does an iPhone or Nexus one really have that much in common with a numeric pager? The Fourth Amendment requires a search to be reasonable. At a certain point, it just becomes so excessive as to be unreasonable, and we may be getting close to that point. It says from pagers to iPhones, the Fourth Amendment to the U.S. Constitution, of course, prohibits unreasonable searches and seizures. It says warrantless searches generally violate the Fourth Amendment, but the Supreme Court has allowed an exception permitting warrantless searches at the time that someone is being arrested, on the grounds that the police should be allowed to look for weapons or items that could be linked to an alleged crime. A second exception to the warrant requirement is, quote, booking search that allows police to establish an inventory of the defendant's possessions. The examination of Taylor's iPhones by the Daly City Police Department was a two-step process. After Taylor was taken to the prisoner processing center, the Daly Center detective, Joseph Bocci, conducted what prosecutors describe as a, quote, limited search of the iPhone. Then, armed with a search warrant, Bocci completed an analysis of the phone's contents. Meanwhile, Taylor's business seems to be languishing. The hypeonline.com blog created after his recent arrest features only 3 test posts, and the linked Twitter account features only a series of messages titled 2,218 new followers within 7 days and making money on Twitter. That included links to a non-existent webpage. Prosecutors say Taylor has prior convictions for forgery, fraud, and identity theft. So, I don't know if I'll get to the bottom here, but I'll try to finish it up for you guys. It says another reason why a search of Taylor's phone was constitutional, said Fiesel, the deputy district attorney, is because of the, quote, transitory nature of that information, because iPhones do present interesting issues with regards to emails, and because the iPhone with the 3.0 operating system does not have a feature known as a remote wipe. The potential for destruction of evidence by defendant further bolsters our argument regarding limited search for incident to arrest. There's a dispute about whether the iPhone is protected with a password, and San Mateo said in court papers that there is no evidence that the iPhone was locked. So, yeah, I mean, it says here, if the government can look at a paper appointment book, why can't they look at a contact list on an iPhone? And so, this is another thing that's going to be passed. And, I guess you could say it is similar to a wallet and contents and that. And so I really don't see this thing not being passed. I mean, to a certain extent, like I said, they are already, cops can do that. In England, they'll grab your phone as well and take it from you. And if you're lucky, if you get it back, whatever pictures you took, they're going to be gone. So, it's just another tool in the arsenal of tyranny. So, Just be careful and think ahead, guys. Thanks.